We have quite a few people in the audience today, and we're going to lay down the foundation and how can you protect your family using trust and wills and durable powers of attorney. So, to start off, a little information about myself. Here at the Soto Law Group, we have myself, I am the owner. We have one other attorney. We're getting ready to bring on another attorney. We have two paralegals. We have a paralegal in training, a legal assistant, a marketing person, and intake. So we are collectively 8 members, and we pull all this together and we protect your family. So, just a little bit about me. My name is Romelia Soto. I was named after my Cuban grandmother, but many know me as Dee Dee. So that's what you'll see. But if you look me up at the state bar, you will find Romelia. I've been an attorney for over 20 years, and I'm locally grown, Cal State Fullerton, Western State, and Chapman. All I do is trust and estate planning, trust disputes, conservatorships. We do special needs trusts. We do limited conservatorships, and of course, probate and child protection planning, right? For those of you who have minor children. So this is the only world that we deal in. If you have a personal injury or a car accident, or if you're bankrupt, or you need to file a lawsuit for something other than in the probate world, that's not us, but we can refer out to you, of course. So that's a little bit about the Soto Law Group and myself. And now we're going to get started and see how we can assist you and your family. So I always like to start off some of these questions, right? People always say, do I need a will? Do I need a trust? What do I need? Why do I need it? Right? So these are the questions that you need to ask yourself. So first, do you own a home? Do you have investments or brokerage accounts? Do you have a retirement account or pensions? What about life insurance? Do you have rental properties, vacation homes? Do you expect to receive an inheritance? Do all of these assets equate to over 184,500? And that's a magic number, I know, and I'll tell you why. But if you have any of these assets and they are not in a trust, then your plan, your estate plan is called probate. And probate should really be a 4-letter word. I know it's not, but I like to think of it as a 4-letter word because it can be expensive. And you're going to learn a little bit more about that. So, what is probate and why do you want to avoid it? Remember that 184.5. So, if you have assets that total 184,500 or more, you're subject to probate. So, basically, if I was to have you raise your hand if you own a home, I have no idea where you live, but I can guarantee you that it's worth more than 184.5, especially if you are here in Orange County and LA, Southern California, probably all of California, right? So that triggers probate. You can have beneficiary designations for brokerage accounts, life insurance, banking accounts, checking, and it can pass by beneficiary, but it can't pass by beneficiary if you own a home or real property. So, how do they figure this out? What is this probate process called? And the probate it used to take a minimum of 1 year. However, ever since COVID and the shutdown, I have been saying that probate could take a year and a half to 2 years. We are starting to get a little bit better. For a while there, we were just closing out probate matters in 2022. And I have to tell you that even this year in 23, we still have some probate matters that started in 20. And guess what? They turned into a dispute. Beneficiaries are fighting, assets have been frozen, or assets have been sold. Other family members are going after it. They weren't sold correctly. They weren't divided correctly. There's all kinds of issues that can happen. So you want to avoid probate, right? And probate can cost you thousands of dollars in attorney fees, creditors, and cost. So here's sort of the probate process. How does this all start? The probate process starts with filing a petition. You file a petition and you have someone appointed. Now, this is if you have a will or no will, right? A will does not avoid probate. Most people think they call up and they say, I need a will. Yes, you need a will, but you also need a trust, right? Because a will does not avoid probate. So you file your petition whether or not you have a will or a trust or not. If you have a will, then it goes through the process, and your beneficiaries that are named in your will be entitled to get whatever you receive. If you don't have a will, then the state directs who's going to receive your assets. Not a good situation. I don't want the state telling me where my assets are going to go. I don't know about you. So then a probate referee gathers all the assets, whether it's a house, bank accounts, brokerage accounts, personal property, jewelry, life insurance, annuities, right? The probate referee gathers all this and they do an appraisal of all of these assets, right? And then from that appraisal, then we have to send out notice. It gets published in the newspaper and all creditors can come forward. So what that means is creditors get paid prior to any of the beneficiaries getting paid. And also attorneys and personal representatives or executors get paid as well prior to creditors and bills being paid. So we have a little bit of authority over that. And so notice has to be given. And if a beneficiary thinks they're supposed to be receiving more money than another beneficiary, etc., they have to file their own petition. They can contest it. And then at the end of the 2 years, approximately a year to 2 years, then everything's paid and you file another petition to say, this is how it's going to be distributed. And these are the assets that these beneficiaries will receive. But if you don't have a will, it will be according to state law. You might not all agree to that, right? And it depends on if you have community property or separate property, if you have a prenup or a postnup. And if it's a blended family, that's when it can really get into chaos. And that's when you really want to get a trust in place. You do not want your family to go through probate because probate will cost 5% of the fair market value of all of your assets. So here's just a little example, right? You have a family residence, $1 million, and that's the fair market value. It doesn't matter if you only had $900,000 in equity or $100,000 in equity. It goes by the fair market value. So rental property, stocks, bonds, life insurance payable to a minor. We're going to talk more about this. If you have a minor, whether it's your children, grandchildren, nieces and nephews, if they're a minor, guess what? They cannot receive assets. So it automatically triggers probate. So you want to avoid that. Retirement accounts, same thing. If there's no beneficiary on the retirement account, it's going to go to probate. Or if you name a minor on the account, it's going to go to probate. So 2.73, nice little nest egg. Probably put a couple kids through college, maybe, whether they're your kids, grandkids, nieces and nephews, or your best friend. But look at this. It cost $135,000 to go through probate. That's 5%. So as that total estimated value goes up, remember, fair market value, this cost goes up as well. And this is all statutory. You can't negotiate it, right? Many times I got to negotiate the attorney fees. No. The state says this is how much it will cost. And filing fees are increasing right now. They're not increasing the attorney fees or the executor fees, but they are increasing the filing fees. So what are the 5 documents you need? You need a will, a revocable trust, financial powers of attorney, healthcare directives, healthcare power of attorney. And finally, if you have minor children, you must name guardians. I have a very unfortunate situation and sad situation going on with the minor right now. And when we get to that, I'll share with you. But you need to have these 5 documents in place. And there's more documents and more bells and whistles behind each one of these, but together they talk to each other and protect your legacy, right? Who wants to leave a messy legacy? So what is a will? Everyone says the reading of the will. I just love this picture. It depicts all the greedy family members coming around. Our marketing coordinator actually found this picture, and I just think it's fantastic because these people are sitting around and want to know what they're going to get. They want to put their greedy hands and paws, as I like to say. I think that dog should get everything, right? But anyway, what does a will do? A will says who gets what and how much they get, because a will does not hold title to any assets. That's why it goes through probate. Even if you have a will, it doesn't hold title. So therefore, probate's triggered. If you don't have a will, then you can't sell the property when somebody dies because the person that died cannot sign the deed or the escrow instructions or get a loan. It's impossible. So somebody has to act on your behalf when you're dead, and that's the executor or the administrator that has been appointed. This is a public process. Who wants to air their dirty laundry to the public? So a will does not avoid probate, and this is all available to creditors, and creditors can make their claim. So again, this reading of the will, all the greedy people coming around, they really don't read the will. Yes, you have to send it out, and sometimes people will put some clauses in their will or trust that they want everyone to gather around. And sometimes they do want to do it like the movies, but normally it's not. So, how do you avoid probate? You avoid it by having a revocable trust, and it has to be funded. So, a trust avoids probate if your assets have been transferred to that trust. Your affairs are private, it doesn't get published, it doesn't get recorded in any trust, iCloud or anything like that. And it passes on your legacy without hopefully any litigation. It preserves your assets for future generations. Believe it or not, yes, it's a little bit of managing from the grave, but you can protect your family, whether it's your nieces, your nephews, your grandchildren, your children, right? And potentially this money can go on for multiple generations if it's managed correctly. And not all trusts are the same. And you can add provisions in your trust so that your daughter, your son doesn't have the right to go buy an Aston Martin when they're 18, or that maybe you want to pay for college, but you don't want to pay for graduate school. Again, it depends on what your estate is worth, what's the value, and what are your values. So we put your values into the revocable living trust. If it's a blended family, you want to make sure that his, hers, and theirs, all of the children are protected. And you can do that by having a revocable trust. You can do that making sure that if you have separate property, that there's a prenup or a postnup that passes on to your children or grandchildren so that it's not lost in divorces, because that is the biggest cut of preserving assets, right? You get a divorce, we live in California, everything's community property. I just want to make a note on that. Your inheritances are your separate property, sole and separate, unless you commingle it. And so as soon as you commingle it, it becomes community property. People can say, oh, no, this was received from my grandmother, my mother, my father, grandpa. It doesn't matter. As soon as you commingle it, all bets are off. So you want to keep it in trust. You can also segregate it so that a beneficiary will receive an asset at 25, 30, 35. Maybe they're more mature at that time. Or you give it to them in trust, and they will be their sole trustee when they're 30 or 35. And yes, they're in charge of it, but it's asset protected. So it's protected against divorces and some potential creditors as well. So really the trust, it's a private document, and it's a way to protect your heirs and also to preserve your legacy. So funding, remember, we create the revocable trust. You are the trustor, the owner, and then you transfer those assets. So the deed to your house gets put in the Soto family trust, or whatever your trust happens to be. And the deed gets put into the house. The brokerage account gets put into the house. Maybe your life insurance, the beneficiary is your trust, so that all of your assets are managed with your revocable trust. As long as you are alive and of sound mind, you are 100% in control. That means you can make amendments and changes. And if your beneficiaries are misbehaving, you can actually change it, or you can push it out and make them get it when they're older. Or if they're really misbehaving, you can disinherit them. So there is all kinds of provisions that you can put in your trust to protect your heirs and to protect you if you become incapacitated. Because if you become incapacitated, you want to make sure that the money is being used for your benefit, not for the beneficiary's benefit. You don't want them coming in and taking your money, pulling out all the equity, because you could become of sound mind again, right? And want to use the money. You want to step in. And so we always say there should be 3 trustees. One trustee is in case you're incapacitated, but what if that person can't serve, right? Life happens. And so we like three. Three is our magic number for trustees. And just because your child is the oldest doesn't mean they should be the trustee. I see this all the time. Sometimes the youngest really should be the trustee. And that's okay. There's no rule of thumb that you have to name your oldest child and go down to your youngest. That is just not a law whatsoever. But some people think that, oh, I have to do that. No, what if your oldest child is not good with finances? What if they have $1 and they spend three? Well, they shouldn't be managing your trust. Maybe it's your middle child or your youngest child, or maybe it's a professional. Maybe it's a professional that's going to step in and be the trustee if you're incapacitated or at your death. Maybe you have four children and they don't get along. Well, I don't know that you should put one of them as the trustee. You might want to have a professional step in. Right now, we have several lawsuits going on where it wasn't my trust, it was other people's trust, but we're having to remove the trustee because they are misbehaving. They are doing all kinds of shenanigans, right? So you want to make sure that who you name as a trustee is the right person because it's a tough job. It really is. There's a lot to do and a lot to manage, and you have a fiduciary duty to make sure that the wishes of the grantor, the owner that set this all up, they're being carried out. And so there's terms that have to be followed too. And there's some liability on your part as well. What is the other document you need to have? So remember, the first one was a will, then a trust, and now it's the durable power of attorney. So what is a durable power of attorney? So a durable power of attorney means that someone can step in and manage those finances even if you're incapacitated. And so this would be, let's say you have a retirement account, whether it's a 401k, a 403b, or an IRA, and you're incapacitated. Well, you have to make minimum distributions, RMDs. Somebody has to do that if you're incapacitated. So you are the principal. Then your attorney, in fact, is your agent, and they can file tax returns for you. They can make the withdrawal from the retirement account. They can make sure your bills are being paid, the lights are on, you have food in the refrigerator, or if you're in a facility, they can pay the bills for you. They act on your behalf. They step into your shoes and manage all of your assets. Now, many people will say, well, I don't need that because I'm married, or my mom or dad is still alive, or I'm only 18. My mom or dad can just step in. Wrong, wrong, wrong. Just because you're married, your spouse is not automatically your attorney in fact. Just because you're a life partner, your life partner is not automatically your attorney in fact. Just because you're 18, 19, 20, 21, your parents are not automatic in managing your finances, and they are not your attorney in fact. This has to be documented. And I promise, I'm not just saying that because I'm an attorney. And not all powers of attorneys are the same too. You can designate what you want your agent to be able to do and not do. If you don't have this and you have assets like a 401k or a IRA, 403b, it doesn't matter, any retirement account, and you become incapacitated, no one can get to those funds. So you have to go to court and you request to have a conservatorship appointed, right? So that is a conservator is appointed over you that's incapacitated, and it's a conservatee. And it can be very difficult to get because you have to have a capacity declaration. You have to be deemed incapacitated, and it costs a lot of money. It's costing somewhere between $500 and $7,500 and above. And if it gets litigated, if family members are fighting over who's going to be in charge of your finances, oh my goodness, it goes into litigation. It can be a trust dispute while you're alive and you're in probate. So that's even worse. You're alive and your assets are going through probate. Oh my goodness. You want to avoid that like the plague, right? That is just not something you want to happen, especially it's probably getting closer to your end of life. Or if there was a health issue that happened earlier, then the court will be in charge and have to oversee this conservator until you pass. There's no deleting the conservatorship once you've opened it. It's complicated, right? You have to file an accounting and you have to pay the bills for the conservatee. It's something you want to avoid as well. Your advanced healthcare directive and your healthcare power of attorney. So now taking care of your health. This is something you want to make sure you have these documents in place. If you're 18 or older, you need to have this. And what is this? What is the healthcare document? So one is a healthcare directive. That's end of life decision. Life support, no life support, close to death, in a coma. You make your wishes known to your family members. Healthcare power of attorney is over your health. So let's just say you're incapacitated, you have a cognitive issue, whether that's Alzheimer's, dementia, or some sort of cognitive issue that you cannot make healthcare decisions for you. And there's a really low threshold in making healthcare decisions for yourself. So you just want to make sure that your wishes are carried out so that if you're unable to make decisions, your family members, friends, whomever that may be, can follow your wishes. And then finally, the HIPAA release. You want to make sure that certain people have the right to your medical records, dealing with insurance company, making sure that your insurance is paying for whatever care you are getting. If you have long-term care, you want to make sure that at a minimum, you have these 3 documents in place. And this avoids a conservatorship because you could go to probate if you don't have these and medical decisions need to be made. Sometimes the healthcare profession will turn a blind eye, but many times they won't. And you'll have to go to probate in order to get the conservatorship, in order to make healthcare decisions for your loved one. And again, you want to avoid that. You don't want to be stuck in probate. Finally, those of you with minor children, or if you know someone with minor children, please make sure they have guardians named. And the guardians are custodial guardians and financial guardians. So we have 2 guardianships that we like to do, the short term and the long term. Short term is someone that can get to your children within 20 minutes, right? It's a family, it's friends, it's neighbors. It does not have to be a family member, nor does it have to be the person that is going to raise your children should the unthinkable happen to you, right? As a premature death. And then, of course, there's the long term. So long term is who's going to raise your children if you're unable to. And this should be someone that shares similar morals, values, spiritual needs, someone that's going to raise your children the way you wanted them to be raised. And again, if you don't name guardians, guess what? A judge will decide who is going to be the guardian of your children. And so maybe it would be your brother, your sister, your brother-in-law, your sister-in-law, but maybe it's someone else that came forward, because what happens is a judge will send out social workers to everyone that came forward. They do an evaluation. They look at the evaluation and they say this person or that person, and that's it. End of discussion. That's who's going to raise your children. And it might not be the person you thought it would be. The judge doesn't know your morals and your values. And we had a situation where there was very amicable between her brother and her younger sister, but she thought her older brother was raising very bratty kids. They had a great relationship, but she did not want her brother to raise her kids. But he was married, had 2 kids of his own. His wife was stay at home. He was a banker. Money was not an issue. Then her younger sister was just graduated from college, trying to find herself, didn't know what she wanted to do. But guess what? She wanted her younger sister to raise her kids because she knew her younger sister would raise them the way she would want them to be raised. And that's where life insurance plays a big part. And so that's another whole discussion as well. Life insurance is a great way to up your estate. And I don't sell life insurance whatsoever, but I'm a big proponent of it. So without a short-term plan, this is what happens, right? Babysitter receives a phone call from a parent. Oh my goodness, where are they? They're not around. They have to call the police, right? Which is Child Protective Services that takes your children, whether it's in a car accident, whether it's the police, the firemen. They don't take the kids to the hospital. They don't take them to the police station, and they certainly don't take them to the fire station, right? They call Child Protective Services, and that is until the temporary guardians can get there, which may be short period or long period of time. And then again, this can create a lot of chaos if you don't have anyone named. And so by naming short-term guardians, this is a way to avoid all of this so that your short-term guardian can say, here's the documentation. And they said that I have the right to take physical custody of your children, because you cannot release physical custody of a minor child without parental consent. So without a long-term plan, this crazy looking judge is going to make the final decision as to who is going to raise your children. and you might not like the plan. Yes, you might, but I don't know. I wouldn't want this judge making my decision if I was you. So make sure you have a long term and a short term for guardians. So procrastination, you know what? I had a couple consults today and everyone always says, "Oh, I've just been avoiding this. I just don't want to deal with it." So procrastination is a silent killer of estate planning. We are working on a guardianship right now, and grandmother was in charge of her granddaughter's estate. She had received a large sum of money from her mom when her mom passed. She was 5 years old, but grandma passed. Then uncle stepped in, and then uncle passed, and then aunt stepped in, and aunt passed. And so we are now on the fourth or fifth guardianship, and this child is not 18 yet. So you want to make sure and get your house in order. You get it done, you check that off your list. We're getting close to the end of the year. I bet probably in January you said, I'm going to get my estate planning in place. Well, we're almost approaching fourth quarter. It's almost October. If you want to get it done by the end of the year, you need to get moving. Whatever decisions you plan today, it's revocable as long as you are of sound mind. And so none of us are guaranteed tomorrow. So why wait when you can do it today? So I think some of you are already scheduled to come and see us, which is great. I look forward to meeting you in person or on Zoom where I can actually see your face and discussing your plan, discussing a plan that's going to work for you and your family. If you don't have anything on our calendar, then now's the time to go ahead and use the QR code. You can use the info. You can call us. We're available multiple different ways. And you do have to fill out a form so that I have an idea. Are you a blended family? Are you single? Are you married? Are your kids minors? Are they adults? Do they have any issues that we need to be concerned about that we can protect? All of that information plays a role in creating your estate plan. And I look forward to working with each and every one of you. And we are a resource. Feel free to go to our website and get lots of information there. And otherwise, I will see you at our appointment.